I'm going to start out by just summarizing a little bit of the case. This is a case of a sitting judge who used a position of power over juvenile friends of his daughter and committed indecent behavior with the juvenile 3 counts while taking them on Florida vacations at his own residence. He was found guilty at a jury trial of all 3 counts and sentenced to serve a total of 13 and a half years at hard. The victims, as you just saw, and family members are opposed to the release. When it comes down to questions, I guess the big question, which is the elephant in the room right now, is were you wrongfully accused and are you still claiming to be innocent right now?
Wearing shackles and a prison jumpsuit and sandals, Jeff PERILLOUX was escorted out the back door of the courthouse where he once served as judge after learning of his 14-year sentence for inappropriately touching 4 of his daughter's friends.
This was a very long process, but I think where we are right now ended with justice, and we're very happy with that.
During a blistering sentencing speech lasting more than 1 hour, ad hoc Judge Dennis Waldron told PERILLOUX he methodically groomed his daughter's friends and took liberties, touching them on their breasts, slapping them on their rear ends, and insisting on giving them full body massages while one time wearing boxer shorts.
I think these young women and survivors were very credible. They've told the truth from day one. And again, like we said after the trial and the verdict, we could not be more prouder of them.
Oftentimes, a defendant can get a more lenient sentence if he expresses remorse for his crime, but that's something that Jeff PERILLOUX did not do.
No, none whatsoever, because he told us early on that he'd rather spend the rest of his life in Angola than plead guilty or admit something that he didn't do.
Well, say it ain't so. A judge convicted of this kind of crime. Well, it's 4 years later and he has his first chance of parole. As a judge, he should know that showing up to a parole hearing and insisting on one's innocence is probably a sure way to get denied. But at the same time, he is backing a relatively long sentence, especially for a man at his age. So will he suck in his pride? Will he tell the truth? I'll unpack it with all the details, including something that he probably doesn't want anyone on this board of paroles to know about. And we have body cam footage. Anyways, with that, let's jump in.
First, Mr. PERILLOUX, I'm going to read some identifying information into the record, ask you to verify it. Then we'd like you to take a moment to tell the panel why you believe we should vote favorably for you today. We'll hear from the warden, those people who indicated they'd like to speak. Then we'll start our parole interview with you. Your case has been assigned to Mr. Barra. He'll take the lead on the interview. So, Mr. PERILLOUX, you are classified as a first felony offender. You're currently serving a 13-year, 6-month sentence, having been sentenced in October 19, 2020. 3 counts of indecent behavior with juveniles. You received a 4.5-year sentence on each of those running consecutive. Your parole eligibility date is April 12, 2025. You don't earn good time, and your full term date is April 12, 2034. Is that information correct, Mr. PERILLOUX?
Yes, ma'am, that is accurate.
So would you take a moment and tell us why you're in jail and why do you believe we should vote favorably for you today?
Sure. Thank you for the opportunity. First of all, I appreciate it. As you mentioned earlier, I was convicted in 2020 of 3 counts of indecent behavior with juveniles. I was sentenced consecutively 4.5 years on each count for a total of 13.5 years. Since I arrived here at David Wade, I have participated in every single class that has been offered to me for rehabilitation purposes. I have attended worship services on a regular basis, continue to do so up through this point in time. I spend most of my time when I'm not working in the laundry, reading or in prayer or conversing with some of my fellow inmates here at the N5 unit at David Wade. I've had a lot of time to reflect on all the things that brought me here to begin with, not just in terms of the case itself and what transpired leading up to my conviction, but also at 57 years old, a lot of things throughout my life. Both the things that I did that were probably considered good, and some of the things that would probably be considered mistakes that I've made in my life. And to be fair, I've had my share of mistakes. However, having said all of that, I think inherently my family will attest to the fact that I am indeed a good person. I have a good heart, and I do try to help others when the opportunity arises. That is inclusive of my stay here in David Wade. I've attempted to be a positive influence on my fellow inmates, have tried to keep them in a frame of mind that allows them to not only excel during their time here, but also to look forward to the opportunity to themselves help others. And so I think when push comes to shove, if I'm given the opportunity to get out and be free again, I do intend to be a contributing member to society like I was for most of my life. I do intend to do those things that not only allow me to be a family man again for my children, but also to be a contributing member to society. And to that end, it is my hope to be able to form a nonprofit group that is dedicated to helping innocent people who have been wrongly convicted in prison, as well as those who have been overly sentenced, and to educate people on some of the pitfalls and traps that they could fall in, perhaps, that might lead them to be questioned about some of their conduct as to whether or not it's appropriate or not appropriate. And so I know it's a tall order, and some may consider it a pipe dream, but fortunately, with my background in law, my background as a district court judge, and my background as an assistant district attorney for 15 years in St. John the Baptist Parish, I believe I have the footwork necessary to be able to establish such a nonprofit group. And so I would hope that today you consider my early release and understand that things that transpired that brought me here to begin with will never occur. I fully intend to completely comply with all the obligations that I'll have in terms of being on parole as a parolee to show that your decision will be meritorious if indeed you grant me that opportunity. So thank you very much. And again, I know your decision is not easy, and I do appreciate it.
Yes, sir. Thank you so much. Warden Dozat, can you add anything for us?
I'll just add that he, since he has been at David Wade for the last 4 years, he hasn't received any rule violation reports. So his conduct has been excellent since he's been here. He's completed reentry, living in balance, stress management, victim awareness, and the sex offender treatment program while he's been housed in N5. And then he currently works in the laundry, and he has a good work evaluation from his supervisor.
Thank you very much. Okay, now we'd like to hear from those in support. We'd like to hear from Valerie. Valerie, if you'd step up to the screen. Morning.
My name is Valerie PERILLOUX, and I'm speaking in support of my father, Jeff PERILLOUX.
But can you speak up just a little bit? Our microphone is on the other side of this phone. We want him to be able to hear what you say.
I am his youngest daughter and will be speaking on behalf of my family. Present here with me today, as stated, my dad's ex-wife, my mom, his sister, and my aunt, his cousin. Unfortunately, my sister could not be in attendance today due to medical school, and his previous attorney, Ms. Kim, was impacted by the hurricane, leaving her unable to be here as well. Each of these individuals, including myself and others, are committed to helping my dad reintegrate in society. Whether it's finding him a job, giving him a place to stay, helping him contribute to our community again, he has a strong support system ready to reunite and heal with him. Growing up, my father has always been a pillar of strength, love, and laughter for those surrounding him. His absence has caused us heartache as we try to navigate life with the pain of separation. Throughout the last 40 years, he has continued to play a vital role in our lives through various phone calls, emails, and in-person visits. His presence in our life is irreplaceable, and I know that he has so much love and wisdom to share. Over these past 4 years, my father has missed many milestones for my sister and I: college graduations, a medical school acceptance, white coat ceremony, birthdays, holidays, to name some. More than those events, he has missed the everyday moments that shape our bond, the laughter, our silly jokes, the lessons, being there for my sister when her 7-year relationship ended, getting a random phone call from his daughters, asking for advice, and the simple joys of being a girl dad, changing my tire when I'm left stranded at school, making sure I'm keeping up with oil changes, giving me a hug when I'm having a bad day, taking me to lunch on a random day. Most importantly, he has missed the sudden, unexpected death of his father in 2021. My dad's presence will not only bring comfort, but also allow us to honor my grandfather's memory as a favor. I believe this closure is crucial for all of us, and it would help my dad continue on his path of rehabilitation. His commitment to personal growth and demonstration of strength and resilience is an inspiration to his loved ones. He has completed courses and earned certificates through the past 4 years and also received a Tiger Risk score of 1. My dad has shown that he is ready to contribute positively to our family and the community. My dad, I miss you deeply and long for the day when we can be together again. Your presence means the world to me, and I cherish all the memories we shared. Regardless of what happens today, know that I am here for you, supporting you every step of the way. Thank you so much. To the members of the parole board, I hope you can see the potential for healing and growth that my father represents for our family. Thank you for your time and consideration.
Thank you. All right, we'd like to hear from the victim's family. First, could we hear from Ms. Guidry? Guidry, are you there? Yeah, we can't hear you. Are you on mute? Can you unmute your microphone?
Thank you. Someone just unmuted my microphone. Thank you for allowing us to be here today and speak. I first want to say that my heart does go out to Valerie and Dominique. I don't wish to see any child suffer, but I have a child as well, and her name is Anne, and I'm here to speak for her today. I am not her mother. I am her stepmother. Her mother could not be here because she passed away of cancer. Something that Mr. Jeff PERILLOUX knew and used to pray and used her vulnerability to pray on her. I came today with an open heart, hoping to hear from Jeff and I'm sorry, or, admitting what he has done wrong, because that's all we really ever wanted. But all I hear is speaking of rehabilitation and starting a nonprofit for people who are wrongly accused. God is the main judge here, right? So he knows. You know what you've done. He knows what you've done. We're all sinners, and we all have faults. I hope the Holy Spirit touches your heart just so we can all just move on from this and have closure. Just say sorry. Just admit what you have done to our children so that we can all move on, so that your daughters can move on. That is a true testimony of strength. That is the truest testimony of strength, to admit that you have done wrong and then go get help. Get help. When you get out, get help. That's it. That's all we ask. And that's all I have to say.
Thank you, Ms. Guidry, for sharing. Appreciate it. I know that was difficult. Now we have the Hotards, and I'll let them decide who's going to speak first.
Hi, I'm here. This is Rachel Hotard. Can you hear me?
Can.
Good morning. Again, I would like to thank you all for this opportunity to speak on our daughter's behalf. She is at work right now, having to take a break to join along on the YouTube. My husband is here on side of me right here at home. First, I'd just like to say, before all this happened, Jeff PERILLOUX was a friend of ours, an acquaintance, somebody that we absolutely trusted our daughter with, to take care of, to protect when, she was with him in his presence, with his daughter that she was friends with. We trusted him completely. We had no reason to not trust him, but then after this incident happened and the trial came, and seeing his actions, hearing the things that happened, we realized how deceitful of a man he really was, and how he, preyed upon our trust of him and our daughter and took advantage of that. And I feel like the same things that he's saying in here right now, speaking of, he's going to make a nonprofit for people wrongly accused, but yet he wants to say he's done his rehabilitation. It's kind of speaking out of both sides of his mouth, where it's either one or the other. I kind of came on with Ms. Guidry in the hopes of maybe we would have had some kind of apology and some kind of admittance to it, but it's not what we're obviously getting here. We're just afraid that he, during the trial was very arrogant, very defiant, and that he did nothing wrong. So our fear is that he gets out and begins to prey upon other people and tries to build that trust again, and ends up kind of doing the same thing to other young girls. Or is he going to still now be in the vicinity of where our girls are? And, that fear of just, those kinds of things coming up again. I just really feel like I need to stress the point that he thinks he did nothing wrong. And he was very convincing and deceitful and conniving. And I just feel like he can't be trusted. I completely feel for his children and the events that Dad had to miss for them, and the passing of his dad, all the events, good and bad. But his actions that he did, he chose this for himself and knew if he got caught, there would be consequences. And he brought that on himself. So I, on behalf of and myself, we just would like to say that we do oppose him being paroled at this time. And we appreciate you taking the time to listen to our concerns.
And does Mr. Hotard wish to speak?
He's right here.
Yes, ma'am. I'd just like to reiterate the point that he never admitted he was wrong, but then he's saying he's rehabilitated. How can you be rehabilitated if you never have come to terms with what you did was wrong? And then to come out and say he's going to do a nonprofit for people wrongly convicted and overly sentenced, that's a passive aggressive way of saying that he's not guilty and didn't do anything wrong. And if he truly believes he did nothing wrong, was to protect the community from this never happening again. And my last point to the board is to please consider the impact on releasing him back into the same community where some of his victims still live. And that's it. Thanks for your time.
So much so. All right, Mr. PERILLOUX, would you answer any questions, Mr. Burrow?
Sure. Good morning, sir.
Good morning. I'm going to start out by just summarizing a little bit of the case. This is a case of a sitting judge who used a position of power over juvenile friends of his daughter and committed indecent behavior with the juvenile 3 counts while taking them on Florida vacations at his own residence. He was found guilty at a jury trial of all 3 counts and sentenced to serve a total of 13.5 years at hard. The victims, as you just saw, and family members are opposed to the release. when it comes down to questions, I guess the big question, which is the elephant in the room right now, is were you wrongfully accused and are you still claiming to be innocent right now?
I missed the first part of your question, sir. I'm sorry. Would you repeat it?
So the first part of it is, were you wrongfully accused and are you still maintaining your innocence today, right now?
The answer to that question is emphatically yes. I was wrongfully accused and I am maintaining my innocence as of today. And I still continue to fight for my innocence in the court system. And I will continue to do so. Even if I'm granted parole, I will continue to pursue the avenues that are available for me to prove my innocence and to be fully exonerated. And let me clarify that real quick by saying this. I completely understand the position that the parents of the girls involved in this case are in. I completely understand that. They have been fed information from the Attorney General's office that have convinced them that I am a predator, that I am not. I am not a child predator. I never have been, and I never will be. And I have to say that whether that sways your vote or not today, I am not going to say that I did something that I did not do for the sake of expediently leaving prison. If I did something wrong, I would apologize for it. And to that end, if any conduct that I engaged in, any conduct or anything that I said ever crossed a level of comfort for the parents or for the kids, I am indeed sorry for that. But I did not commit sexual crimes against any of these girls, period.
Where do you plan on living and what do you plan on doing if we were to release you?
Well, my plan right now is to move in with my sister, whose husband, by the way, is a police officer, has been for over 30 years. I would be living in their residence. He would keep an eye on me just for the sake of protecting the community, if indeed there is a concern within the community that I might do something like this again, according to the statements of the parents. And my intention at this point in time for employment is to go into the seafood business, which my father was in for over 40 years. I intend to go into something completely different in terms of what I've done for my entire professional career, but a career that I'm also familiar with due to my dad's involvement in the seafood business for over 30 years. And that would be on the wholesale side of things.
That's all my questions.
I've got something. Mr. Perilloux, let me ask you something.
Yes,
The text that you sent the girls.
Yes, ma'am.
That at first they said that you were, well, they felt like you were like a second father to them. They trust.
Correct.
So that was the level of influence that you had over them, which is often seen in these types of cases. It's going to be a father, stepfather, close family member, something like that. So let me ask you, they spoke about the text being weird as to what you would say to them, and you would give heart shapes at the end and different things like that. And then some of the questions that you would ask them, did you send those types of questions with those types of emojis to your own daughters at that same time frame? If we were to compare the text to your own daughters, because they said their own daddies would not have sent them those types of texts, and they wouldn't have ended the text the way you did with hearts and stuff like that. Did you do that with your own daughters?
I did. With not only with my own daughters, but with my nieces as well. My sister has 2 children who are older than mine, who were like my first daughters, okay? The emoji stuff that you're talking about, ma'am, with all due respect, and the little heart symbols, that was a new feature that was on the iPhones around the time that these communications occurred. I was tinkering with those little text message features. I guess that's what you'd call them. I'm not overly tech oriented. However, those heart messages were just that. They were simple ways of saying, I love you in a paternal type way, because I did view these girls as family members, just like I did with my own daughters, obviously, as well as my sister's 2 daughters. I was affectionate and I was kind. And if that offends anyone, then of course, I'm sorry for that. That was never my intention. My intention was to show them how important they were to me, in a paternal sense, not in some perverted predatory sense.
Well, that's why they had problems with it, because it wasn't paternal, the way those messages came across, because they said their own fathers didn't end their messages the way you did, and then phrase his messages, Papa J loves you, and then end it with these emojis and stuff, thinking of you and smiling, you make me happy, hi with a drawn heart. You are my sunshine. So it wasn't sexual in nature, but for the girls, it was odd. But you were so important in their life, they gave you leeway with that type of stuff. And then when I asked you, just how did you do that with your own daughters, you said no, but you did it with your nieces. Why did you make?
I did it with. I didn't say no. I said yes. Not only did I do it with my own daughters, I also did it with my nieces. Those
okay, so let me ask you about touching.
Well.
Let's get into the touching, because you're saying you didn't do anything. So let's get into the touching. You know, like these were young teenagers. And here's some of the stuff that was unusual. If suntan lotion, you insisted on putting it on these young girls. One girl needed some vapor rub. She said that she just needed some vapor rub, and you did rub it on her chest. Those things are not normal for a grown man to do with anybody other than an infant. So why did you think those things were not crossing the line? Because they did. So why did you not think that? Well,
first of all, let me just, I will answer that question, but let me finish my point on the text messages. Every message I ever sent the girls was not done in a surreptitious fashion. Their parents could have seen any of these messages at any time, and if they had an issue with the manner in which I communicated with the girls, they certainly could have told me something. I did not have any communications with Miss Hotard's daughter. Emily Hotard received no text messages ever from me, not one text message. I didn't even have her number. The only two girls who I texted were one who has not accused me of any crime, who is not involved in this case as a victim, and the other was Miss Guidry's daughter, who I had texted for probably 4 years before anything happened. As far as the touching was concerned, the only times that I ever touched these girls were at their request, and it wasn't on a frequent basis. Anna Guidry had a problem with her neck after she would swim, her shoulders. She would ask me at swim meets and or at home when she was with my daughter if I would simply massage her neck a little bit. These were not full body 10-minute, 20-minute massages. These were little 30-second, let me try to loosen your neck up a little bit type touching. That was the extent of it. As far as the vapor rub incident, which is the misdemeanor that isn't involved in what you all are dealing with today, yes, that was something that I did, who had been in my life since she was 1 year old. And I put vapor rub right here. It took me all of 3 seconds to rub vapor rub right here. If you can see me, that's where I put the vapor rub, right here. It wasn't an ongoing type thing or a frequent thing that I touched these girls in any way, nor did I have any desire to. There were limited occasions where I did indeed engage in physical contact. And to the extent that that physical contact was deemed to be inappropriate or crossed some line of comfort, I am sorry for that. But that was, my intention was never to touch them inappropriately, ever, not once.
Okay, but do you think these girls all said consecutively their daddy wouldn't do that? So I guess, I mean, we're just gonna
y'all hear me
on this, so we're not gonna go any further with this because you don't see that there was a problem with it. I do understand, but I do understand why they loved you and they let you do things that they felt like this shouldn't be happening. And then when the one girl came out of the room crying that it went too far for her, then the others admitted she had done things that went too far for them. So, you know, you had the one girl that your daughter was her best friend since what, they were in the 2nd grade. You got a lot of broken hearts on both sides.
I am aware of that, and I feel horrible about that. I do. These people, as Ms. Hotard said, were friends of mine, generational friends. We're talking about friends of their parents and my parents and their grandparents and my grandparents. We're talking about generational friendships that have been fractured as a result of this. And honestly, I think communication early on could have avoided some of this, and maybe, yes, maybe better decision making on my part. But at the time, I did not think about the negative side of physical contact because I didn't intend to touch them inappropriately. So I just want to make sure you all understand. Yes, I totally understand the feedback that the parents are offering here, but I have to make it clear that my intention was never nefarious with these girls. I truly considered them to be like family to me, and everything I ever did for them or did with them was from a familial type standpoint. In hindsight, yes, ma'am, it may very well not have been the best decisions, but at the time they were made, I had no idea that any of the girls were uncomfortable with me on the manner in which I treated them. And that is the best way I can
Time
put,
out
quite
one
frankly.
sec, just 1 second here. Okay, time out. We're gonna move on, and I understand where the girls were coming from. So that's the end of my questions.
Anything else you'd like to say, Mr. Perilloux? Before we
I did not hear you, ma'am. I'm sorry.
Anything else you'd like to say?
No, other than, again, I appreciate your consideration. I know as not only as a longtime attorney, but as a judge, decisions are not easy when they involve these types of situations. But I want to make it perfectly clear before you vote that I never, ever intended to do anything to harm any of these girls or in any way touch them in an inappropriate fashion. The outcome that we see now is not at all what I intended. And I sincerely apologize for that. And again, I thank you for your time.
I think the panel's prepared to vote. Mr. Barra?
Mr. Perilloux, you are right. You do bring us to a very tough decision. But obviously the jury didn't believe your side of the story. And so what I'm gonna have to do is I'm gonna have to vote to deny parole today based on the serious nature of the crime and that you only serve 4 years off of the 14-year sentence, which is a fraction in the strong victim opposition. I'll suggest that you keep on doing exactly what you're doing and reapply at your next option after you serve just a little more time, because 4 years off of 13 is really not justice for the jury verdict.
Mrs. Stapleton?
I concur with Mr. Barra.
Mr. Perilloux, I also agree that it's insufficient time served based on the jury verdict. I do wish you well. My vote is to deny for those reasons. I do wish you well in your quest to appeal. Good luck to you, sir.
Thank you.
Where's my gavel thing? I need to slam it down. Get back to your cell. New pillow for you, Mr. Judge. You know, it was a good board for this. Renatza, Barras, and Stapleton. And I like how you know, the very, I think probably the most like black tie professionals on the board in the sense of how they kind of like handle their business. But I do wish we had a Miss Jackson and Mr. Mirabella, 2 former judges. I just have a sense that they would have laid it in. I don't know. It's just a sense. And, you know, something about him being a judge. And I wanted a little bit more of a speech, but it was handled well. They asked the questions. We had Miss Stapleton, our survivor advocate, that did probe in there and didn't let him get away with it. And the survivors spoke so elegantly, so succinctly, and so like compassionately for him, for his family, and really just stating one thing. They just wanted him to admit it. It was very unique, very pure. You know, we're going to go, there's a lot of information Sir Richard found on this case. We're going to go over the appeals. We're going to look at the information. But for those of you who are watching, who have some doubt and say, well, maybe, you know, maybe he is innocent. You know, maybe he's I'll say to that, where there's smoke, there's fire. There's something that was caught about him not so long ago. And instead of me describing it to you, we can watch it firsthand, and then I'll come back to unpack.
This story starts on Airline Highway in St. John Parish from the dash camera of a local state trooper's car. See if you notice what the trooper spotted. Back up the video. See the car on the left of your TV? Stopped in the middle of the road with the lights off. The trooper immediately turned his lights on. What ensued was not your ordinary traffic stop.
Stop! Stop! Hey! Stop! Get out of the car! Get out of the car! Get out of the car! Get out of the car!
This happened just after midnight, nearly 20 months ago. State police just gave us the video this year.
Do not move. Why are you pulling off? I'm behind you trying to talk to you and you pull off from me. Why are you sitting in the middle of the road? Where are you going? Why were you stopped in the middle of the road with no lights on? Now I come up to talk to you to find out what's going on and you pull off. As I'm telling you to stop and I'm screaming at you. Then you pull in here and keep going. Then I tell you to get your hands up and get out of the car, and you're going to reach into a spot that I can't see in the car. How much you had to drink tonight? Nothing. Nothing at all? What's that odor of alcoholic beverage coming from your breath that I smell? That's nothing? No, it's a function.
The man in the car, Jeff PERILLOUX. At the time, he worked for St. John Parish government. The state trooper quickly found out his job title and the power he tried to use.
You have a St. John officer here, okay, friend. Can you just tell him that perhaps he can get me home?
He didn't stop it, sir.
I know, sir, but
I did.
But sir, you know who I am.
Huh?
You know who I am? I'm the parish attorney.
Okay.
You're gonna embarrass me.
Turn around, sir.
Parish attorney. That's fine.
Turn around.
Hey, do what you gotta do.
Turn around. Hands on your best.
Thank you, sir. That's great.
PERILLOUX worked for the district attorney Tom Daly, serving as the parish attorney for St. John, the top legal advisor for the parish government.
You know who I am?
No, sir.
Sir, I am a assistant district attorney.
Right now, you're under arrest. You have the right to remain silent.
You're degrading me right now, but I am an assistant district attorney.
Okay.
You are degrading me, and this is horrible.
Okay. Come on back here.
That's fine. I'm an assistant district attorney, man.
When they got in the trooper's car, PERILLOUX turned even more confrontational.
He is the parish attorney and ruined it. You understand that? You think I'm gonna sit back and take that? The very next thing I do is talk to your boss. But I know you don't care.
Mr. PERILLOUX.
No, sweetheart.
Mr. PERILLOUX, listen to me. Okay?
No.
You need to mind what you say and ensure that you do not make any threats.
Congratulations. You're taking the parish attorney and making him a move. I did nothing. You could have said, you know what, Jeff, can I follow you home? I'm a state trooper. I'm going to follow you home. You didn't. You decided to be an That's your choice, not mine. And that's okay with me. I am the parish attorney. I'm not some little lowlife.
The trooper brought PERILLOUX into the St. John Parish Jail. According to a police report, PERILLOUX continued to be belligerent. We were able to get some video from inside the jail, but no audio. The only account, the police report. The report says PERILLOUX came in with slurred speech and a strong odor of an unknown alcoholic beverage. PERILLOUX repeated countless times that he has been the parish attorney for 10 years and is an ADA for St. John. The officer wrote PERILLOUX repeatedly yelled expletive you and made obscene gestures. He then told them to go expletive, expletive Tom Daly, who is the St. John district attorney. And officers wrote, he said, I will destroy you, saying when he is DA in 2 years, he will remember what we did to him. PERILLOUX refused to submit to a breath test. When the officer told him the refusal would cause his driver's license to be suspended for 1 year, again, PERILLOUX responded, expletive you.
First, he starts asking for favors. And then when the officer does his duty, he resorts to foul language and threatens him to have his job and destroy him. that is crossing the line.
The Metropolitan Crime Commission filed a complaint with the State Bar Association, asking them to review the tape and the police report. The Attorney General handled this case. The AG rejected the public intimidation charge.
I think unequivocally you've seen a public official attempt to use his position to intimidate and suggest that law enforcement not perform their sworn duty.
The DWI charge against PERILLOUX has been expunged, erased. That's not necessarily uncommon for a first-time offender. PERILLOUX still works for St. John Parish government. He resigned from the DA's office 2 months after this arrest, but soon after, the parish council hired him as its attorney. He makes $125 an hour.
The fact that he's still employed by, in parish government, he ought to consider himself fortunate.
And Goyeneche says fortunate on this September night, authorities didn't pursue charges that PERILLOUX tried to use his job, his status in the community, to get out of driving drunk.
You could have said, Mr. PERILLOUX, I will help you get home. I apologize that, tonight I was a hard night. Mr. PERILLOUX, I'm going to warn you a second time and the final time. I don't care what you have to say. Okay. I really could care less what you have to say. You made it clear you don't care who I am.
And there you have it. Can you imagine that he then went through his career as the DA and then made it to a judge? He got through this, but like I said, where there's smoke, there's fire. I mean, you're still not convinced? You're still saying, well, this has nothing to do with it, Mandu, which, okay, from a legal perspective, it has nothing to do with it. But I think when you're looking at a judge of character, look, DUIs happen, but you're going to use your power to try to threaten someone, to say you're going to fire someone, you're going to go after someone. I mean, that's a whole different level. If you're still not convinced, all right. We can go over the appeal. So let's do that. Facts. The case involves allegations that the defendant engaged in a pattern of inappropriate behavior with young teenage girls in an effort to groom them for escalated acts of inappropriate touching. At trial, State presented evidence to establish that the defendant, formerly a district court judge, committed acts of indecent behavior with juveniles. AG, EH, and count 1 and 2 and E. Okay. Who were his teenage daughter's friends? The state also presented other crimes or bad acts evidence, including allegations that the defendant had also committed misdemeanor S battery upon SB, which would be a third victim, who was another one of his daughter's friends. All three counts of the incident behavior with juveniles, as well as a misdemeanor S battery on SB, were alleged to have occurred at the defendant's Louisiana residence between May and December of 2017. In response, the defendant and his daughters denied that he inappropriately touched AG. So I guess his daughters were brought up as witnesses. Can you imagine having to have your, I mean, can you even imagine it? I can't, thank you, Sir Richard, for both. There's a lot of information. We're going to stick to this appeal and not there, but there's a lot. And, he being a judge, of course, he's tried everything, but we get it all in here. So Florida encounter prompting disclosure requirements. Victim AG testified that at the time of trial, okay, not at the time it happened. She was 18 years old and had graduated in 2020 from St. Charles Catholic High School. Again, I'm sorry, can you imagine you send your kids to private school only to have the judge do this? The judge who's the father of your child's friend. Okay, I'll shut up. She explained that she had been lifelong friends with the defendant's daughter and had also a special relationship with the defendant, who was like a second father to her. She first reported that the defendant inappropriately touched her breast shortly after a disturbing encounter with the defendant during a trip to Florida in 2017. AG was 15 years old when she went on the trip with the defendant, his 2 daughters, Valerie and Dominique, and 2 other teenage girls, SB and Madison. Defendant was the only adult on the trip. On the night of July 13, 2017, the girls decided that AG should ask the defendant for a later curfew so they could go to the beach. AG recalled that she and Valerie went into the defendant's room and briefly talked to him. But then Valerie walked out because she did not want to be in the room with AG. Asked to be in the room when AG asked, to extend their curfew. After Valerie left, the defendant began playing with AG's shirt and rubbing her stomach over her shirt while he was lying in bed. AG testified that the defendant then began to slide his hand up and under her shirt and that his fingers touched her when he moved them under her swimsuit bottoms and down towards the bottom of her swimsuit. This is the first time I'm reading this. So, AG backed up and said no. Defendant then asked AG, "Let me do your top," which AG believed to mean that he wanted to touch her boobs. AG testified that after she backed away, the defendant kept saying, "Can I do your top?" And she continued to say no. She asked the defendant if they could stay out later on the beach, and he again said, "Let me do your top." And I'm this close to saying yes. Can we extend our curfew? Let me do your top. I am this close to saying yes. AG explained that she believed the defendant was implying that if she allowed him to touch her, they would get a later curfew. AG then started walking away, and the defendant stood up, grabbed her hand, and said, "Don't be scared. You don't have to be scared." AG kept saying no to what he kept asking her to do, and after a while, the defendant sat back down on the bed and told her that she and the other girls could do whatever they wanted. AG testified that she was scared of the defendant after the encounter. Can you imagine that you're 15? It's like your life all of a sudden at that moment changes. You can't make this stuff up. This is not something 15-year-old girls make up. It's just ridiculous. He's sitting there saying, "I am innocent. I'm going to open a non-for-profit." I love what they all said, talking out of 2 sides of his mouth. Indeed. After AG left the defendant's room, she told SB and Miss Simpson about her encounter with the defendant and how he had touched her. SB testified that AG was really red in the face and crying, and so they went outside to talk. When SB asked AG for more details about where the defendant touched her, AG put her hand near her swimsuit bottom and explained that the defendant went in the front of her swimsuit bottom. SB then told AG she needed to calm down because Valerie and Dominique would be coming out and they did not want to have to tell them about what the defendant did. AG told SB she did not want to tell anyone else what happened, but SB knew they should report the incident. The next day, Miss Simpson told her best friend, who was dating AG's brother, about what had occurred between AG and the defendant. When AG's brother learned about the situation, he called AG and told her she had to tell her father and stepmother. Good job. Good job. AG testified that the evening after the incident, she called her father and stepmother, who were vacationing nearby. And good job on stepmom, by the way. Acting, like it's her own daughter. Good job, stepmom. Really, really what she had said, how she said it. I was touched. After they learned about their encounter with the defendant, AG's parents told her they were coming to pick her up and that she should wait for them at the Waffle House near the condominium where she was staying with the defendant. AG testified that she told her parents not to contact the police because she did not want anyone to get in trouble. AG then told Valerie that she did not know what was going on, but that her parents needed to pick her up. While AG was packing to leave, the defendant walked into her room, gave her a high five, and asked, "So we're cool about what happened?" "Yes, Judge." Very cool. Very cool indeed. AG's parents contacted the police after they talked to her. Shortly after they arrived at the Waffle House, a police car pulled up. Detective Timothy and Deputy Thomas of Okaloosa County Sheriff Office in Florida. This is familiar. Okaloosa. Wouldn't it have been great if it was Sheriff Chidi? That would have been perfect. Arrived at the Waffle House and interviewed AG in parking lot in the presence of her parents at trial. AG testified that she told the officers that the defendant went under her shirt and down into her swimsuit, but she backed away before the defendant could touch her private part. In the body camera video, AG began crying when officers asked her what happened. We don't have this footage. She told them that the defendant put her hand under her shirt and started rubbing her stomach when she asked him to extend their curfew. AG also stated that she backed up, but he kept saying, "Let me do your top." She stated that she told him no, and that he grabbed her hand and told her not to be scared, and that he subsequently walked out of the room. When officers asked for additional information about what occurred, AG confirmed that the defendant tried to go down into her bathing suit, but that she backed up before he could do anything. Count 1 and 2. So now they're going to move on to the additional counts. And this is a long appeal. For those of you who are not interested in the facts, hey, you can. That's why I do the unpacking at the end. If you still want to leave an angry comment about it, that's fine too. I'm in a good mood. I can handle it today. So counts 1 and 2, indecent behavior with juvenile. AG told the officers that the defendant previously touched her before this incident in Florida, but that she did not report it and had been denying it because the defendant was her best friend's father. The officer did not ask AG for additional details about the prior touching, but when one of the officers suggested that she was blocking it out, AG agreed. The following day, on July 15, 2017, AG participated in a forensic interview style with a child advocacy center in Florida. AG testified at trial that she was scared and did not want to be there after explaining, you know, imagine you're going on a Florida vacation. It's supposed to be epic. It's like you and 4 or 5 of your friends, best friends for life, and then it's blown up. You're now you're getting interrogated by a presenter. Like, you just wanted to go to Disney World, and then you got this, and their lives were turned upside down, all because of this creep judge. And we always, when these judges, we always say, "Oh man, it's got to be the judges." And I know not all the judges are, into this stuff, but man, when you see the laws and the minimum sentences that are allowed for certain crimes, it only makes you ask the obvious question. Okay. After explaining the incident with the defendant that occurred in the condominium on the evening of July 13, 2017, AG disclosed Ms. Knapp that the defendant had inappropriately touched her breast on prior occasions. AG explained that the defendant was massaging her back and then came into the front and touched her breast. When Ms. Knapp asked for details about where it occurred, AG first told her that she was at the defendant's house and that Valerie was sitting next to them, but Valerie did not see what happened. She also told her that this happened one time and that it occurred a month or two ago. Later in the interview, she asked for more details about AG and Valerie and where the defendant's house when he was messaging AG. AG then told her that she and EH were in the defendant's room sitting in a bed and that they decided to do a massage train. She said Valerie was sitting on the bed and then left. AG explained that she began massaging EH's back and the defendant was massaging her back. Ms. did not ask for any further details regarding how the defendant touched her breast. So he's doing this in the room with his daughter there. Is that what I understand correctly? At trial, AG testified that the defendant touched her breast on 2 separate occasions at his house in Louisiana, and therefore it was not accurate when she told her that this is the only occurred one time. AG explained that she put the 2 events together during the Florida CAC interview. See, now they're trying to, of course, discredit her. And when she participated in a second CAC interview in Louisiana, December 2017, she was better able to recall the 2 occasions when the defendant touched her breast. At trial, AG explained that when the defendant touched her inappropriately the first time she was at the defendant's house in Laplace, Louisiana, on the sofa in the living room, the defendant came low with his hands on her chest, and his hands were inside of her bra and on her breath approximately 10 seconds. AG testified that the second time the defendant touched her is where the defendant's bedroom. The defendant asked them if they wanted a massage because that's a completely normal thing for a fully grown adult male to ask his teenage daughter's friends. They responded affirmatively and engaged in a massage train on his bed. AG recalled that they were massaging each other with EH in front. The defendant, AG, and EHG stated that the defendant then said to her, "Let me do you now." So she and EH swapped places. She testified that during the massage, the defendant moved his hands down fully on me and that his hands were on my nipples. Under her bra for approximately 15 to 20 seconds. EH was in front of her, and therefore EH was not in a position to see what had happened. So that's, I guess, no, that's not his daughter, that's his friend. AG explained her friend that she thought about telling someone after this occurred, but she was scared of being called a liar or losing her best friend. Count 3, indecent behavior. The victim in this case, count 3, EH testified that she had known AG and Valerie since elementary school and that she and Valerie were best friends who did everything together. EH testified at the trial that she had traumatic experience at the defendant's house when she was 14 when the defendant applied sunscreen all over her body. She explained that she and Valerie wanted to play on a slip and slide outside. EH recalled that she and Valerie were about to apply the sunscreen and the defendant offered to help. Again, a completely normal thing for fully grown men to offer to do. EH said she told the defendant no several times, but he insisted on applying the sunscreen on her. She stated that, and as Miss Stapleton said, the only time a fully grown male should be doing this is a toddler. Pretty sure Miss Stapleton said that. Like this, it's so inappropriate in so many ways. He's like, yeah, I did it. I'm sorry if it hurt people's feelings. EH said she told the defendant no several times, but insisted on applying the sunscreen on her. She stated that the defendant rubbed it all over me, and I just completely froze. I tensed up, and I stared out the window the whole time, and he just rubbed it all over me. She further explained that the defendant went in the outline of her sports bra and her shorts to apply the sunscreen. EH did not tell anyone what the defendant did to her because she did not want to lose Valerie's friendship. EH also underwent CAC forensic interview in Louisiana, January 25, 2018. In the interview, EH explained that the slip and slide incident occurred on July 2017 before the beach incident with AG. That was before the beach incident. Stated that the defendant used his hands and rubbed another charge. This is the S battery charge for SB. The victim in this case involved in the misdemeanor battery testified that she was 20 years old at the time of the trial, and she also graduated from St. Charles Catholic High School. SB testified that the defendant's daughter, Dominique, was her best friend since preschool. It's just, again, it's like, oh, but you know, seeing him drunk in that body cam footage, my guess, just speculation, there's no proof, is that he's probably had a drinking problem. He's probably drunk here and he's sloppy drunk and that's my guess, but none of them are saying that, but that maybe they're not allowed to say that because they don't know. I don't know. Is that, or he was completely sober. He just didn't care. SB testified that the defendant's daughter, Dominique, was her best friend since preschool and that her mother had worked for the defendant. SB also stated that the defendant was like her second father. SB testified that in November or early December 2017, she slept over at Dominique's house. Her throat was hurting her badly and she thought she had a fever. SB asked Dominique for medicine. They went into the kitchen. The defendant came into the kitchen in his underwear, again, completely normal, and they explained that SB had a sore throat. The defendant said he did not have pills or liquid medicine, but he had Vicks Vapor Rub. SB then put the Vicks Vapor Rub on her throat, after which the defendant took the medicine from her and told her she had to put it on her chest. Yeah, that makes sense, for sure. SB was wearing a loose shirt without a bra. The defendant pulled up her shirt open and stuck his hand in her shirt to put on the vapor rub. SB explained that the defendant then started touching the sides of her breasts. SB told him no several times and asked the defendant to let her apply the medicine, but he told her, no, I got it. The defendant applied several layers, and SB told him he did not have to put that much on. SB explained that she was so exhausted from being sick, and after several attempts to stop the defendant, she just let it happen. SB did not think the defendant touched her accidentally, and after this occurred, she realized that maybe the whole time AG was telling the whole truth, and that she should have trusted AG and been there for her. Oh my God. SB explained that that she stopped talking to AG after she made the allegations against the defendant because she was scared to lose her friendship. So SB testified that coming forward about this incident, she lost her friendship with Dominique and Valerie, the two people she thought she would always have in her life, all because of this prick judge, selfish, disgusting. It's just so sick, you know? It's just so sick. And here he is still insisting, I am innocent. I am going to open a non-for-profit for wrongfully convicted Judge Chomo Roaches. So, as you can see, it goes a long. And I'll put this link in the description. I'm not going to read the whole thing. I don't think anyone wants to hear me read this entire thing. I think we get the point, right? You have to let me know. It's hard for me to judge, right? It's hard for me to judge about what everyone's looking for in these unpackings. It's not like I am the qualified reader for these things. I think it's probably at best tolerable for most, you know, who want some information, but it's not like I'm a trained reader. It goes on. There's more. I mean, there's a lot in here. I've read enough, I think. Then they had the defense testimony. Should we go through that? Is kind of interesting. So after the state rested its case, the defendant testified in his own behalf. I am curious about this. So the judge, who probably recommended that you never to 10,000 times those who represent themselves as a fool for a client, got on the stand. The defendant explained to the jury that he graduated from law school in 1993, after which he practiced law, worked for St. John Baptist Parish District Attorney's Office, eventually was elected district court. I could have just imagined him like the classic narcissist that takes the stand and he's sitting and talking probably for like hours on end, thinking that he's winning over the jury, thinking that he's discrediting these children. The defendant admitted that he was arrested for DW in 1999, after which he pled guilty. How were they allowed to bring that up? I wonder why that was allowed into evidence. Okay, that's a different question. I'm sure there's reasons. And later had the conviction expunged. No kidding. Can you imagine having that conviction expunged? If that's not corruption. We saw that DWI. Oh, wait a minute. That's a 1999 DWI. Is the DWI that we saw? I don't think the DWI we saw is from 1999. Anyways, that's actually a good question. We'll come back to. Also admitted he was arrested for a second DWI. There we go. In 2010. That's the one we saw. 2 DWIs in his record. And he's allowed to be a freaking judge. Pled guilty under Article 894 and later had the conviction expunged as well. Wow. Do we not need to see corruption? Can you imagine 2 DWIs and caught on body cam where how do you get that record expunged? We've seen how difficult it is to get records expunged in Louisiana. It's not Connecticut. It's hard, but there we are. We've been here for 23 minutes, but I'm happy we read on. The defendant explained that he underwent rehabilitation afterwards and he'd been sober for 10 years. It only makes it worse if you were sober, sir. The defendant testified that he had never been alone with AG, SB, or EH, and that he had treated them like daughters. He stated that he started engaging in text messages with AG in 2015 and recalled that after AG's mother died, her father began dating another woman. He testified that AG had moved in with him and his family 1 month before AG father remarried. The defendant testified that his daughters and the other girls worked together in Riverland Country Club and then invited all of them to a Florida trip. He further testified that the subject of the alcohol came up in Florida trip, that SB asked for alcohol and he said no. He said that AG then said her parents let her have beer and daiquiris occasionally, and Ms. Simpson told him that her mother sometimes let her have a drink when she was with an adult. The defendant testified that based on the girl's request, he bought some pre-made frozen daiquiris, 2 small bottles of fruit-type drink. He was not aware that AG had brought a pint of Malibu rum on the trip. The defendant maintained that he had allowed his daughters to drink alcohol on the Florida trip, but other than that, he did not allow them to drink. So apparently there was some stuff about that. All right. I'm probably going to read this on my own later. This is, to me, is pretty interesting. But we get the point. And they go over with blah, blah, blah. They found him guilty. The dude's guilty of sin. So he's going to go and talk about being innocent, and he's going to be in prison a long time. He's, he's 57 years old, if I'm reading that correctly. And he's got what, a full term date of quite some time. So I think his full term date is 2035. So he's got a lot riding on this. But anyways, thank you, Sir Richard, for providing this case. Thank you also, CH0M0 Overcomer, for sending an email about this and saying, Mandy, make sure you cover it. I always do appreciate when y'all do that. And with that, I'll let you go.
We're all sinners and we all have faults. I hope the Holy Spirit touches your heart just so we can all just move on from this and have closure. Just say sorry. Just admit what you have done to our children so that we can all move on, so that your daughters can move on. That is a true testimony of strength. That is the truest testimony of strength, to admit that you have done wrong and then go get help. Get help. When you get out, get help. That's it. That's all we ask. And that's all I have to say.
You said you were young and dumb. How old were you when this was involving a 7-year-old and a 9-year-old? I don't know how your son was.
2001.
So how old were you?
26, 25.
Not that young and dumb. Maybe, not that young. So you're 26, 25 versus a 7-year-old and a 9-year-old. Was your son your victim also, like your wife said?
He was 8 years old.
We are about to watch a disturbing parole hearing of a man who did this to his biological children. What's equally as disturbing is that he was initially given a suspended sentence and probation. He did not have to serve 1 day in jail until he was caught living with little ones again. I'll unpack it with the details at the end. Buckle up.
So, Mr. Manning, you're classified as a first felony offender. You're currently serving a 25-year sentence. You were sentenced originally in April of 2003, aggravated incest and indecent behavior with a juvenile. Looks like you were afforded probation. However, that was revoked in 2011, December of 2011. You have a parole eligibility date, April 15 of 2025. You don't earn good time, so your full term date is in August of 2031. Is that information correct, sir?
Yes, ma'am.
Mr. Manning, would you take a moment and tell us why you believe we should vote for you today? What got you into jail, and why do you think we ought to grant you an early release?
Well, being young and dumb and not understanding things you do is why I'm in jail. And through the years, learn wisdom. I start to understand. Basically a changed man from what I was 20-something years ago.
All right, Warden Dozak, what can you tell us about Mr. Manning?
Well, Jason's been here since 2015. He did get his GED in 2008 at West Carroll facility. He is active in the 12 steps and he has reentry program. Completed anger management, sex offender program, substance abuse in October of 23 and victims awareness in November of 23. He just recently started the SurfSafe class, which he will finish early December. So he just started that last week. We do have an approved residence plan at the Veterans Housing Outreach in New Orleans. And his employment plan is to work in the restaurant industry. He does have a good evaluation from his work supervisor, and his last write-up was in 2018, and he hasn't had any disciplinary issues since then.
All right, thank you very much. All right, we'd like to hear from those who wish to speak. First, we'd like to hear from, I don't know, are y'all together? No?
We're not together.
No, ma'am.
Okay, let's hear from first.
Okay. Yeah. So when asked earlier this morning what my relationship to Jason was, I froze. And not for the reasons that most would think. My initial thought was I was the victim, of course. That's why I'm here. But y'all already knew that. You have a list of us victims. Y'all wanted my actual relationship. Should I say sperm donor? I can't say father. He wasn't Matt. Thank God for a mother that heard my hesitation and she spoke up for me. I don't like to take on the victim role. I never have. But this man 25 years ago tried to take away my innocence. He took away my childhood. He took away my rights at having a normal family, a father, an idea what it meant to grow up with a complete family. To not blame myself for everything when it was not my fault, because my whole child and adolescence, I was told it was my fault that Jason was in jail and that I could get him out by his family, by all the Mannings. He took away any happy childhood memories I've ever had because I blocked out all of my memories to keep away all the bad memories. I was later diagnosed with heart issues called POTS that linked back to childhood trauma. It can be caused from always being in a fight or flight mode, and this has affected my day-to-day health. But through all of this, I want y'all to know, and I want Jason to know, that he does not get to choose who I am today and how I get to live my life. I am not that little girl, and I am not a victim. I am a survivor. I'm a warrior, and I want to fight for others that have been in my shoes and prevent them from being in my shoes. And if that means keeping him from getting parole and creating new victims, then I will do everything in my power to do so. And if there's anything that I can help clarify that I've spoke on or the notice that I sent in before, please let me know.
Well, Ashley, thank you so much for speaking to us today. I know that takes a lot of courage, and you're a very strong woman.
Thank you.
We hear from Ms. Chadwick.
Yes, ma'am. I mean, as you heard from my daughter, it is still affecting my kids to this day. And the original charge was 3 children. My son was included in that charge, but because he broke down and was inconsolable on the stand, they were not able to charge him with 3 counts. He was only charged with both of my daughters, 2 counts. And so all of my kids are still this far out reeling from something that was clearly not their fault. And the fact that he blames or says it was because he was a young person, and this was young and dumb. It doesn't take a smart or an older person to know that you don't hurt children, period. You don't hurt children. And I don't know if, I mean, he was physically abusive with me. And I always thought that that would stop with me. I didn't realize that it would flow over into my children, but this is who he is as a person. This is substantially him as a person. The only reason that he is in there and doing quote unquote well is because he's in a controlled environment where he cannot hurt other people. And for that, I am thankful. But by letting him out, you're giving him an opportunity to hurt more people. Not my kids. My kids are grown and they are working through their issues. Even to this day, they are still in counseling. But I mean, there's other children that don't deserve this either. So wherever he goes, I mean, this is pathologically who he is. You know, he doesn't understand the difference between right and wrong, and you don't hurt kids, period. It doesn't matter if you're young and dumb. I mean, I've never met anybody who didn't draw the line. You don't touch kids. And I really strongly request and pray that you consider this and do not let this man out for parole. My kids are serving a life sentence, and they will for the rest of their lives as they try to, you know, continue to battle this. I mean, it affects them day to day, even today, in their relationships. So if they're not getting a break, I don't think he should either.
Yes, ma'am. Thank you. We appreciate you taking the time to speak with us this morning. All right, Mr. Manning, would you answer any questions Ms. Stapleton has for you, please, sir?
Good morning, Mr. Manning. Tell me about the classes that you've taken, so we can go ahead and talk about that for a second, and then we'll talk about the crime. What classes have you completed?
The phase 4 sex offender class.
Okay.
12 steps. I'm a member of AANA. Anger management. And a couple other classes.
Yeah, I see here victim awareness. Tell me something about, tell me about the sex offender treatment class. I mean, after taking that, do you see anything about it that makes you understand what your daughters and according to your ex-wife, son went through?
Oh, yes, ma'am. I learned a lot in it. I like the assault cycle and sexual content that teaches of the laws, caddis over him.
What?
Yeah, it teaches. I learned victim awareness is where I learned most of the stuff about what happened to the children. What they went through.
All right. And what did the sexual offender class teach you about how this happened and what you did?
It taught me it affected everybody. From my kids to my ex-wife to my mom, my brother, everybody in the family, basically to the community and everybody.
Well, specifically, what about the watching with the children? Let's start there.
Yes, ma'am. It was I know it was wrong now.
You know it was wrong now. And then another thing, you said you were young and dumb. How old were you when this was involving a 7-year-old and a 9-year-old? I don't know how your son was.
2001.
So how old were you?
26, 25.
Not that young and dumb. Maybe, not that young. So you're 26, 25 versus a 7-year-old and a 9-year-old. Was your son your victim also, like your wife said?
He was 8 years old, and no, ma'am, he wasn't there.
He wasn't your
They
victim?
proved that in court. No,
Well, I
ma'am.
know it goes
He
on
was a
to court.
victim. He was a victim because they was his sisters, but
Yeah, but you're saying you didn't do anything with him. He didn't have to watch any pornographic movies and you didn't touch him inappropriately. Is that what you're saying?
no, ma'am. I didn't do anything. What I was basically doing was trying to show my daughters about if somebody did try to molest them or did try to touch them.
Are
and
you
what to do.
kidding? Oh, really? You're
No,
gonna tell
ma'am.
me that you would put pornographic movies on a TV for children to watch to say, don't let this happen to you, when parents don't even want children to listen to curse words on TV.
When they
So
acted
you
like they didn't
understand when you got
understand what I was
charged.
telling them,
Huh?
when they acted like that they didn't understand what I told them, yes, ma'am, I did.
Well, that's when parents say this, don't let them touch you in places where your swimsuit's not at. Or if it makes you feel bad, you come tell daddy and daddy's gonna take care of it. That's the kind of training children get. That's a poor excuse for what you did. What about the touching? The actual touching, were you teaching them then that this is the kind of stuff you don't want to have done to you?
Yes, ma'am. I
Oh,
was
my.
showing them where it was proven in court that they had their clothes on. I mean, I was the dad that stayed with them. I
And so,
was Mr.
so
Mom.
there's where we go
So,
with this, that you were their father, the man that
yes,
they
ma'am.
trust. And that's what we see so often. You know, they talk about stranger danger, but actually when it comes to sexual and molestation and aggravated rapes and stuff like that, it's going to be, most of the time, it's going to be the daddy, the stepdad, the uncle, the grandfather, somebody who holds that position in their life. It's not going to be, in most cases, especially with children, a stranger. It's going to be somebody they trust. And then how long did this go on? It went on for years, didn't it?
No, ma'am. It was proven in court. It happened one time.
Well, I've got here from January of 1995 to October of, well, let's see. So January of 1995, and you're saying it happened one time. Did they just tell us that?
My daughter wasn't born till April of 95.
It says aggravated incest. Oh, I'm sorry. That's when you were charged. So when did it start?
I was charged in 2002. It happened in 2000.
It happened in 2000?
Yes, ma'am. I was an at-home dad. I stayed with the kids 24/7 for a whole year.
Oh,
Wife
so
was at work.
it happened during the
couldn't hear.
time you were staying home with the children?
Yes, ma'am. I was being Mr. Mom at that time.
Okay. I don't have any more questions.
Yeah, I have a question. It looks like this case started out as a suspended sentence and you got a probation in this case. How did that probation turn out?
I was on probation for 4 years. The last year I failed drug tests. I went to rehab. After I graduated rehab, I never failed another drug test, but the PO picked them up from the months before. And they told me it'd be in my best interest to violate myself. So I thought I was gonna get a 90-day turnaround. That's what the law was then. I didn't understand.
But that drug test, that wasn't your only violation, was it?
Sir?
Was that drug test your only violation?
Yes, sir.
And they gave you 15
for
years for
marijuana.
violating a drug test?
20 years, sir.
I'm looking at the record and it's something different than that. It says, in August of 2011, it was discovered that Mr. Manning had changed his residence and was living in another residence with his girlfriend and her children. for approximately 2 months. Mr. Manning was not officially charged. This was a violation known as a failure to register as a sex offender charge. Changing his residence and residing with minors was also considered major violations of the sex offender conditions. Several positive drug screens, including marijuana, were also noted on the motion to revoke.
Yes, so they proved it.
Offender conditions too. And that's
They proved it.
They didn't prove it?
Yeah, I went over there to the house when the kids were at school or the kids were going to their grandparents or the boyfriends and girlfriends' houses. I explained to that in court. And everybody else did too. I did go over there. It was my girlfriend. She came over to my house.
All right.
But the reason I violated my own parole was because of marijuana.
All right. That's all. Thank you.
All right, Mr. Manning, anything you want to say to us to close it out?
No, ma'am. I wish I could go back and change everything. I'm real regretful that I've hurt my family. And I can't explain how much I feel bad about it.
Here, I want to tell you, you did get your GED since you've been incarcerated. Congratulations on that. I know that's
Yes, ma'am.
achievement for you. I think we're ready to vote. I'll be voting first. I listened very carefully to what Ashley and Ms. Chadwick had to say. I've read the record. I've looked at what the record says, your reason for the judge revoked your probation. Today, sir, my vote's going to be to deny your parole for those reasons.
Yes, ma'am.
I agree with Mrs. Renazzo. Strong opposition that we heard, and I agree with
Mr. Barra.
I concur with both of my colleagues for the same reasons.
All right, good luck to you, Mr. Manning.
Thank you.
You know, isn't it interesting? We're just talking about the kind of judges that are on the bench. If you didn't see it, we covered the judge that ends up getting convicted of doing it to his daughter's friends, little, children. And just thinking about all the sentences he agreed to as he was on the bench. Sentences like this, where this man, I mean, look, we'll get into talking about him and we'll get into talking about everything, but let's remember that this cockroach was given a suspended sentence, probation. And we don't have appeals. We don't have court records. I actually don't have information I can unpack, but he's talking about it like he went to court. He's talking about what's proven in court, which, by the way, he's found guilty. He's found guilty in court. Whatever it was, if it was a bench trial or a jury trial, he was convicted of aggravated incest. He was convicted of indecent behavior with the juvenile and 2 counts of each. And a judge says probation? What? But we've seen this before. And it turns out, thank you, Mr. Barras, for pulling this up, that he finds a girlfriend with kids again. And he goes and he moves in there. Can you imagine how long the trail of victims that he has left behind and the people responsible for that, for giving him probation? It makes no sense to anyone who's not a PhD, who's not in the judiciary, right? We're not judges or DAs, so what do we know? But think about it. We just saw a man who's already been through programs, who's been locked up, who's had all the time to think about the best answer he could give. And the best answer that he gives is I didn't do anything. You know, I was showing my daughters a video so they would know what's out there. I was showing them adult content so they would know. That's the best answer they got. So think about the ammunition and the clarity that the DAs and the judge, they would have had. Imagine if he took the stand. I mean, the PSR, everything that he would have said, it would have been so clear that this guy is like a danger, that he's not taking accountability, that he's like, and they still say probation because clearly he's not a threat to anybody. Obviously, he was showing them that content so that he cared about his 7 and 9-year-old daughter, so they would know how to act if someone did that. Obviously, that's what was happening. Why would I ever doubt? Why would I ever doubt those put in charge to protect us? Shame on me. Man, do. You can't make this stuff up. How many judges, DAs are playing on that side of the court? There's no other explanation in my mind. Even in the legislation in Louisiana, those that write the laws, the sentencing just covered a case where the maximum the guy could have gotten for what he did was he slept with his stepdaughter, got her pregnant. She was 14, so they had DNA. You know, they had the DNA. They had the royal flush. They had the smoking gun. He got 7 years. And then I look in the legislation, the maximum they were able to give him, because it wasn't first-degree sexual assault, it was considered just second-degree, was 10 years anyways. The maximum the court allowed for that, impregnating a 14-year-old girl, was 10 years anyways. I mean, the system is broken, at least in Louisiana. And I love the way Miss Stapleton handled the case. She starts off, well, you weren't so young and then she caught herself, well, you weren't young. and then she makes it very clear. She starts off, she's like, let's start with your programs and then we'll get to the case. And she was doing that because it's procedural. She didn't care what programs she took. And she goes at him like only the survivor advocate can. She's great. I like this panel, actually. I like Mr. Knotts in the middle. She's letting them go with it. She's letting Barras and Stapleton go at it. I like Barras. It's a very I like the panel. Now Mr. Freeman's growing on me, and I love the sheriff. So really, any mix of, I think, throwing Mr. Freeman and the sheriff, take one out, and it's a good panel. But it's nice seeing them all work together. And the survivor, the way she spoke, I mean, what a speech, huh? What an incredible speech. She's standing up. She's like, I'm going to be a survivor. She called him a sperm donor. She said, when they asked me what relation, I don't know, a sperm donor? Yep. Just a cockroach. That's all he is. Now, the sad part about all this, and think about this, take it in as painfully as it is. His full term date is 2031. 7 years, he will be out. He will be 57 years old. Think about the years that he has under his belt to reoffend. That's a scary thought. But that's the sad reality. That's the truth of it. And how many parole hearings do we cover of those who, kind of minorish crimes that get longer sentences, and it'll never make sense. But thank you, Sir Richard, for putting these hearings together. And we'll leave with that mic drop from the survivor as the final words of today's hearings.
So when asked earlier this morning what my relationship to Jason was, I froze, and not for the reasons that most would think. My initial thought was I was the victim, of course. That's why I'm here. But y'all already knew that. You have a list of us victims. Y'all wanted my actual relationship. Should I say sperm donor? I can't say father. He wasn't Matt. Thank God for a mother that heard my hesitation and she spoke up for me. I don't like to take on the victim role. I never have. But this man 25 years ago tried to take away my innocence. He took away my childhood. He took away my rights at having a normal family, a father, an idea what it meant to grow up with a complete family. To not blame myself for everything when it was not my fault, because my whole child and adolescence, I was told it was my fault that Jason was in jail and that I could get him out by his family, by all the Mannings. He took away any happy childhood memories I've ever had because I blocked out all of my memories to keep away all the bad memories. I was later diagnosed with heart issues called POTS that link back to childhood trauma. It can be caused from always being in a fight or flight mode, and this has affected my day-to-day health. But through all of this, I want y'all to know, and I want Jason to know, that he does not get to choose who I am today and how I get to live my life. I am not that little girl, and I am not a victim. I am a survivor. I'm a warrior, and I want to fight for others that have been in my shoes and prevent them from being in my shoes. And if that means keeping him from getting parole and creating new victims, then I will do everything in my power to do so.